Hello, and welcome back to Elise Explains IP. In episode 6, we looked at foreign words as trademarks and when they might be considered to be descriptive under Australian law. Today, in this episode, I want to follow up that with a real-world case study that shows the limits of enforcing foreign word marks, even when you have that favourable High Court decision in your pocket. This episode looks at the recent federal court decision in the long-running dispute between Cantarella Brothers and just about every other coffee producer in the world, but in this case specifically Lavazza, over the word oro, again, and how the court managed to sidestep the earlier High Court ruling without contradicting it. If the word oro sounds familiar, it should. As we discussed previously, oro, which is Italian for gold, has been one of the most litigated coffee trademarks in Australia. In 2014, Cantarella successfully defended its oro registrations in the High Court, which confirmed that foreign words are assessed under the same distinctiveness test as English words. Fast-forwarding almost a decade, and Cantarella is back in court, this time alleging that Lavazza, not Moderna in the previous case, but Lavazza, infringed its registered oro trademarks by using oro prominently on its coffee packaging and in advertising. And on the face of it, this looks like a really strong infringement case. But the decision shows that valid registration and enforceability are not the same thing. Like last time, Lavazza's first line of defence was to try and say that it wasn't using oro as a trademark at all. It argued that the word was being used descriptively to indicate quality. Ba-bong! That pesky old High Court case is coming for you. Justice Yates rightly rejected that argument. The court reiterated the important principle that words can function as a trademark even if it has a descriptive element. Despite oro not being the dominant feature of Lavazza's packaging, the court found that it was used prominently, it stood out visually, and it was capable of operating as a badge of origin. So Lavazza was using oro as a trademark. At this point, Cantarella looked well placed to succeed. But here's where the case took a decisive turn. Lavazza brought a cross-claim, arguing that Cantarella's oro trademarks were invalid because Cantarella was not the true owner of the mark in Australia. Instead, Lavazza pointed to an Italian coffee producer, Caffè Molinari Oro, which had used oro on coffee products supplied to Australia before Cantarella's priority date. Importantly, Molinari never registered oro in Australia, and its earlier use had been considered, but not fully evidenced in the 2014 High Court case. This time, however, new evidence of use was put before the court. Cantarella argued that even if Molinari had used oro, it had abandoned the mark. Abandonment is a concept with very little judicial guidance in Australia. It requires intentional abandonment, not just non-use or reduced use. Justice Yates made a critical clarification. The question was not whether Molinari used the word oro. It clearly had. The real question was whether Molinari used oro as a trademark rather than merely as a descriptive term for gold quality coffee. Looking closely at Molinari's packaging, the court examined, once again, size, colour, positioning and prominence of the word oro. On that evidence, Justice Yates concluded that Molinari was using oro as a trademark and that it had not abandoned it. That meant Molinari retained prior rights even without registration. This is the most important part of this decision. Justice Yates took care not to disturb the High Court's findings on distinctiveness. A single court of the federal court can't overrule the High Court. But Justice Yates affirmed that oro does not have any ordinary signification in Australia, that it is inherently adapted to distinguish, and that foreign words are not assessed by their translation alone. Instead, Justice Yates pivoted, and the case was decided on ownership, not distinctiveness. In other words, Cantarella's trademarks were distinctive, but they were not validly owned. So that distinction allowed the court to effectively neutralise Cantarella's registrations without contradicting the High Court. Because Cantarella was not the true owner of the oro marks, its infringement case failed, and its registrations are likely to be cancelled by consent. Cantarella may still retain common law rights based on reputation and may pursue claims under the Australian consumer law, but this is a far more difficult and weaker position than a registered trademark enforcement. The key takeaways for brand owners is that there are 3 major lessons from this case. Firstly, registration does not guarantee enforceability. Ownership of your trademark matters, and earlier unregistered use can be fatal. Secondly, foreign word marks are fragile. They may survive distinctiveness challenges, but they remain exposed to ownership and use-based attacks. Thirdly, evidence is everything. Had this evidence of Molinari's use been available in 2014, the High Court decision may have been very different. This case underscores the importance of comprehensive clearance searches, investigating unregistered use, and keeping detailed records of brand use from day one. The Lavazza and Cantarella decision shows that even the most well-known brands can find themselves on shaky ground if ownership isn't secure. Foreign words can be powerful branding tools, but they come with long-term enforcement risks that need to be understood early. If you are building a brand around a foreign word or enforcing an existing one, this is a reminder that trademark strategy doesn't end at registration. And as always, thank you for listening to Elise Explains IP. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.